All right, this is case number 24CV091, Kevin and Marty Martin versus Tyler Miller. The plaintiffs are present with their counsel, Katie Wilkin. Defendant is not present. The records reflect that Mr. Miller called to court, when was it, 2 days ago, and indicated he was ill. He thought the hearing was that day, and then this morning he called and said that he thought he had a bacterial infection, but he was informed that the hearing would go forward, and he is not present. The court will also note that he is in default for failure to answer the complaint or otherwise defend. And so the matter before the court then is on the subject of damages. Ms. Wilkin, I note that the allegation, I understand it, is that the plaintiffs paid him $40,260, which and then you're seeking a total of $98,526.41. The allegation is that the cost of materials and work now is in excess of what the defendant would have charged them. So I can hear evidence on that.
Thank you, Your Honor.
Yeah.
Your Honor, would you prefer that the witness testify from the stand?
Yeah, I think it'll be better. It's easy to pick up. So if you want to call whoever.
We'll call Kevin Martin, please.
All right, Mr. Martin, if you would come right up here. If you would raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Have a seat there. That's a microphone that's right there. If you would slide that as far as it'll go towards you. And,
There we go.
And speak into it, please. Yes. All right, you may inquire, Ms. Welcome.
Thank you, Your Honor. Good afternoon, good morning. Can you please state your name and spell your last name for the record?
Kevin Martin, M-A-R-T-I-N.
Thank you. And Mr. Martin, do you reside here in Highland County, Ohio?
I do.
Can you please state where you live?
12541, State Route 124, Hillsboro, Ohio, 45133.
Thank you. And can you tell me, when did you come to purchase the property in Highland County?
Over a year ago. It's probably been 2 years now.
Okay. And previously you lived in Claremont County, correct?
Correct.
And what was your desire to move to Highland County? What was the game plan?
We were going to build our dream retirement home.
So you had gathered some retirement funds in order to build your home?
Sure did, yeah.
Okay. And at some point, did you come into contact with a Tyler Miller?
I did. He was recommended as somebody that could help build what we wanted.
Okay. And at some point, did you have a in-person or over the phone conversation with Mr. Miller?
Multiple times, yes.
Okay. And to your recollection, what was the agreement between you and Mr. Miller?
Mr. Miller would purchase the supplies, hold them until we were ready to build, and he would help assist in building.
Okay. And were there specific items that he was to help build, or was he to do the entire home?
He was going to assist with the home, but he was going to build the barn, help with the septic system, help with getting the rest of the house situated, and I would finish the inside.
So he was there to assist you as well?
Yes.
Okay. And at some point, did you initially speak with Mr. Miller about what a cost would be for the work he was going to assist you with?
It was general. It started off with, I can get you this done at a certain price, and then, hey, I found a better deal, I can do this, you know. So it just kept adding up, but there were specific things.
Okay. Your Honor, if I may.
Go ahead.
Thank you.
Plaintiff's Exhibit 1.
Yes, Your Honor. All right. I'm going to hand you what's been previously marked as Plaintiff's Exhibit 1. Can you take a look through that packet for me and let me know, do you recognize that?
Yes.
And can you tell me, what are you holding?
These are receipts or proposals from Tyler Miller, what he would do.
Okay. And let's go one by one. We'll refer to the first page as 1A. Can you please tell me, what is that proposal for and what amount was provided to you?
Okay, this was for building a pole barn 32 by 40, or building 32 by 40, and a subfloor using I-joist and advanced tech OSB boards, beams, And that came to about $8,300.
Okay. And if you could please go to the second page, we'll refer to it for the record as 1B.
B. Okay, this is for the barn package, the 36 by 50 pole barn. That he said he could get for $11,000. We will build for $3,000 extra and can have built in 1 week.
Okay. And what was the date of that one?
6/8/23.
Is this 3,000 in addition to the original estimate?
Of the 11,000, yes.
11,300?
Yeah, 11. Yeah, it was 11,000 for the pole barn and 3,000 to have it put up.
Okay.
And if you could please go to the third page there, we'll refer to it for the record as 1C. And what was the date of that proposal?
7/13.
Okay, and can you tell me what was that proposal for?
This was for the heating air conditioning system, the mini splits. It was like a 3-head mini split Lennox system. Is priced, installed by Davis, and I think that's Hughes,
And what was the price for?
$4,000.
Okay,
And the date on that was 7/13/23.
okay. And then can you go to, I believe it's the final page there. And we'll refer to it for the record as 1D. Can you tell me the date of that proposal?
7/3/23.
Okay, and can you please tell me what that proposal was for?
That was for a 400 amp electrical box and wire. And the total cost on that is $1,500. It was $1,000 up front and $500 90 days later.
Okay, and can you tell me with those 4 proposals, plaintiff's exhibits 1A through 1D, are those fair and accurate copies of what you received from Mr. Miller for work that he was proposing to do for you?
That's what he proposed, yes.
And those are fair and accurate
Yes.
to the day that you got?
Yes.
Okay.
Yes.
Okay, thank you. Now, can you tell me, was any of the materials that were proposed in these proposals actually delivered to you?
Some was.
Okay,
We'll start with the mini split. I think that was the third one. It was supposed to be a Lennox system. It was not Lennox when he delivered it. It was some other off-brand 3-head mini split system, heating and air conditioning. It was not what he proposed here.
okay,
He did not provide the 400 amp box or the wire. I had to pay an electrician to do that.
okay. How about the pole barn? Was it a package or
There was a generic package delivered. It was not all delivered in one time. It took multiple weeks. He delivered part of the wood package wrapped up and set outside. He did not deliver the outside metal work, like the door hangers and the screws to put the metal up. I had to keep bugging him to get that delivered. He finally delivered it, and it was the wood package was warped and bent, and we had to have an additional crew come in and buy additional materials and put the barn up.
Okay. And can you tell me, did he actually bring all the materials or did he complete the work on any of the 4 proposals in total?
No, he did not complete the work in total at all.
And did you, or to your knowledge, did Mrs. Martin reach out to him and try to get him to complete the work before coming to an attorney?
Multiple times, every time there was an excuse.
Okay. And about how long do you think you went through trying to get him to come and complete the work and bring the materials that he had promised?
A year. It was easy a year.
Okay. And other than the proposals that we've already gone over, States Exhibits 1A through 1B, can you tell me, did you also have any other conversations where you paid him for other materials?
Yes.
Okay. And those weren't put in a proposal, but those were agreed to orally by Mr. Miller and you over the phone?
Correct.
Okay. And were you able to provide checks to counsel of all of these payments?
Yes.
Okay. If I have a moment, Your Honor.
Is that video at 10:30?
Your Honor, if I may.
You may, go ahead.
Thank you, Your Honor. We're going to go through these one by one, Mr. Martin. I'm going to hand you first Plaintiff's Exhibit 2. Can you please tell me, do you recognize this?
Yes.
And can you tell me what is that?
That's a check for $7,300 to Tyler Miller.
And is it from your account?
Yes, it is.
Okay. And what is page 2 of Plaintiff's Exhibit 2?
That would be looks like a bank statement where Tyler deposited, cashed the money and deposited.
Okay. So he did cash this check?
Yes.
And what date was the check for?
June 5th of 23.
Okay. And did you put anything in the memo line of what this was payment towards?
Looks like logs and subfloor.
Okay. And does that fairly and accurately depict that check that you paid for the logs and subfloor?
Yes.
Okay. You can set that to the side. We're going to move to the next one. I'm going to hand you what's been previously marked Plaintiff's Exhibit 3. Can you please state what you are holding?
Another check to Tyler Miller for $9,500 with the memo barn.
Okay. And page 2 has what?
Another bank statement where Tyler cashed the check.
Okay. And can you tell me, does that fairly and accurately depict the check that he cashed for the barn?
Yes.
Okay.
What's the date on that check?
Date on this check is 6/8/23.
Thank you.
I'm going to hand you what's been previously marked as Plaintiff's Exhibit 4. Can you please tell me what you're holding?
Another check for Tyler Miller, $1,500, and the note says barn additions,
Okay. And what date was that for?
6/8/23.
Okay. And what is the second page of that?
Another photo of where he cashed the check.
Okay. And does that fairly and accurately depict the second check on June 8th of 2023 that you paid to Mr. Miller that was cashed?
Yes.
Okay. I'm going to hand you what's been previously marked as Plaintiff's Exhibit 5. Can you please tell me what that is?
This is another check to Tyler Miller for $1,300. There is nothing in the memo on that one.
Okay. Can you recall what that might have been for?
It's probably for the part of the mini split.
Okay.
So
And what date was that for?
6/15.
And was that of 2023?
Yes.
Okay. And what is page 2? Okay.
Another photocopy of where he cashed the check from the bank.
And does that fairly and accurately depict the check you wrote on June 15th of 2023 that Tyler Miller cashed?
Yes.
Okay. I'm going to hand you what's previously marked as Plaintiff's Exhibit 6. Can you please describe what you're holding?
Another check to Tyler Miller. The date on this is 6/18/23. The amount is $6,450. The memo says insulation package.
And what is
Insulation?
Insulation.
And what is page 2 of that exhibit, please?
This is a photocopy where he cashed a check at looks like Homeland Credit Union in Chillicothe.
And does Plaintiff's Exhibit 6 fairly and accurately depict the check that you wrote back on 6/18/23 to Mr. Miller that he cashed?
Yes.
Okay. I'm going to hand you what's been previously marked as Plaintiff's Exhibit 7. Can you please describe what you're holding?
Another check to Tyler Miller on 6/26 of '23, $5,100. The memo says roof lumber.
Okay.
What lumber?
Roof.
Roof?
And can you please describe what's page 2 of State's Exhibit 7? Plaintiff's Exhibit 7, apologies.
It's a photocopy of where Tyler cashed the check. Looks like Homeland Credit Union, Chillicothe.
And does Plaintiff's Exhibit 7 fairly and accurately depict the check that you wrote back on June 26th of 2023 and that Mr. Miller cashed?
Yes.
Okay. I'll hand you what's been previously marked Plaintiff's Exhibit 8. Can you please describe what that you were holding?
Another check to Tyler Miller. The date 7/3 of '23, $1,000. The memo on that is electrical.
Okay. And can you please describe what page 2 of State's or Plaintiff's Exhibit 8 is?
It's a photocopy of where he cashed my check.
And the State's Exhibit 8, Plaintiff's Exhibit 8, I'll get there to plaintiffs at some point, fairly and accurately depict the check you wrote back in July of 2023?
Yes.
And that Mr. Miller cashed?
Yes.
Thank you. I'm going to hand you what's been previously marked Plaintiff's Exhibit 9. Can you please describe what you are holding?
A check to Tyler Miller for $5,010. And the memo on that says windows, and the date is 7/12 of '23.
Okay. And what is the second page of that?
It's a photocopy where he cashed the check at LCNB National Bank.
And does Plaintiff's Exhibit 9 fairly and accurately depict the check you wrote to Mr. Miller back on July 12th of 2023 that he cashed?
Yes.
Okay.
Excuse me, what was the amount of that again?
$5,010.
And it was for?
Windows.
Okay. All right, counsel, I've got a 10:30 video with the state of Ohio, so I'm going to dial that in now for an arraignment. And we have a really devil of a time getting them, so we have to take what they give us, so we're going to go off the record for a minute here. All right, this is case number 24 CR 86, State of Ohio versus Rebecca Deere, L. Deere. You are Rebecca L. Deere, appearing there from Marysville?
Yes.
All right. Ms. Deere, you were indicted by the grand jury of this county back on June the 4th on a charge of aggravated possession of methamphetamine, a 5th-degree felony, and it alleges that on or about February 5, 2024 in this county, you knowingly obtained, possessed, or used methamphetamines. Well, that's a 5th-degree felony, which carries a possible penalty of 6 to 12 months incarceration, fine of $2,500, and a possible license suspension of 6 months to 5 years. Now, you're entitled to have counsel, and I see you did fill out a financial disclosure form. Everything on that is correct?
Yes.
Okay. All right. The court then will appoint attorney Sarah Barger of Hillsborough, Ohio, to represent you. In the absence of counsel, I'll enter not guilty plea on your behalf. We will set a video arraignment for you sometime next month as we can determine with the institution. We'll have a final pretrial in person on October the 2nd at 1 o'clock. He'll be returned for that. And then the trial date will be set for October the 21st at 8 a.m. And what is the sentence you're serving right now, Ms. Deere?
3 years.
I'm sorry, I can't hear you. Wait a minute, let me turn up my volume.
3 years.
What is it?
3 years.
All right, and all right, so for now there will be no bond, will be a holder placed on you, so that in the event you should be released from custody, you'd be returned to Highland County for a bail hearing. All right, we will notify your attorney of her appointment, and then, like I said, we will set up a video conference for a pretrial. You'll be able to talk to your attorney by video before that, and then we'll have that hearing. It'll just be a short hearing, and then you'll be returned in October for your in-person pretrial. Do you have any questions?
No, that's all. Thank you.
Okay. All right. Your attorney is Sarah Barber, so she'll be the one who'll be getting in touch with you. All right? Okay. Thank you.
All right,
Mr. Martin, we're back on the record. We previously went through State's Exhibits 2 through, Plaintiff's Exhibits 2 through 10, marking the checks that you paid to Mr. Miller, correct?
I only have the 9. I don't think you covered 10.
Oh, sorry, apologies.
Yeah,
I'm gonna
that
hand
was
you
for
with-
$5,010 for windows.
Correct.
Yes, apologies, Your Honor. Can you please state what you were holding in Plaintiff's Exhibit 10?
Another check to Tyler Miller for $4,000. Memo says HVAC, which would be heating, ventilation, air conditioning. The date on that is 7/13 of 23.
And what is page 2 of Plaintiff's Exhibit 10?
A photocopy where Tyler cashed the check.
And is Plaintiff's Exhibit 10 a fair and accurate copy of the check you wrote to Mr. Miller that he cashed on July 13th of 2023?
Yes.
Thank you. And Mr. Martin, when Mr. Miller did not show after you paid him these checks, did you have to reach out to other contractors and stores in order to get materials to complete some of these projects yourself and with others?
I did have to reach out to other people to get the job, or at least get started with the job.
Okay. And were you able to provide some of those to us before court today?
Yes.
Okay. I'm going to hand you 2 exhibits. I'm going to hand you Plaintiff's Exhibits 11 and 15, and we're going to discuss those. Can you please describe what those are and who they're from?
This is from J Brothers Construction.
Now let's do 11 first. What is 11?
11 is a broken out receipt, or a detailed receipt from J Brothers Construction related to the 30 by 48 by 12 barn project.
So for these materials, I'd like to go back to Plaintiff's Exhibits 1A through 1D. You had indicated that Mr. Miller had dropped off portions of a pole barn package, correct?
Correct.
Okay. Now, Plaintiff's Exhibit 11, is that in addition to those materials, or is there duplicate materials? materials?
Yes, this is in addition to what they needed to put the barn up.
Okay, so
To
these are the materials that did not get delivered?
Correct,
That would have been delivered with Mr. Miller had he completed what he was supposed to do?
correct.
Okay, and can you please tell me what is the price on the additional items that you had to receive?
$15,400, including labor.
Okay, and I'd like now to switch to plaintiff's exhibit 15.
Okay.
Can you please describe what that is?
This is the receipt from J Brothers with the date of 10/9/23.
And does it have the same pricing that
Yes.
you earlier received?
This $15,400 for the barn package.
And does both plaintiff's exhibit 11 and plaintiff's exhibit 15 fairly and accurately depict both the detailed of what you're receiving for the barn and ultimately what you paid for the barn?
Yes.
Okay, thank you. I'm going to hand you what's been previously marked as plaintiff's exhibit 12. Can you please describe what that is?
This is an estimate where I had to go and check for materials that weren't provided to see if I could go ahead and get them purchased. It's from Lowe's Home Center, and it was for windows.
Okay. And did you ultimately have to purchase additional windows because he did not bring what he was supposed to bring?
I could not purchase the additional windows because of the cost.
Okay. So the cost he had quoted you was much lower than the cost of what
Yeah.
you then went to check?
This is just part of it, and this is the lowest grade window.
Okay, and what was the lowest grade window that you could get?
$4,505 and $4,505.
Okay, and how many windows was that for?
That was for 15 windows,
Does that fairly and accurately depict the lower grade windows?
the very
that you had to
lowest.
look at?
Yes.
Okay, thank you. I'm going to show you what's been previously marked as plaintiff exhibit 13. Can you please describe what that is?
This would be for the skylights that were supposed to go around the wraparound porch. And this was an estimate from Lowe's. It's $224.85 per window, and Tyler was supposed to provide 4 skylight windows.
Okay, and he did not provide those?
No, he did not.
Okay, and what were the total for those?
$3,526.
Okay, and does that fairly and accurately depict the estimate for the skylight windows?
Yes,
Okay, and that's 4 of those?
yes.
Okay. I'll hand you what's been previously marked plaintiff's exhibit 14. Can you please describe what you're holding?
This is another estimate from Lowe's for the windows and doors that Skylar didn't provide or bring that he said he had.
Okay. And can you tell me, are these the same grade that you had initially agreed to with Tyler?
These are,
Those
yes.
are. Okay, and can
Yes.
you tell me what the total cost of those windows and doors were?
$32,620.35.
Okay. And does that fairly and accurately depict the amount that had to have been paid for the materials that Tyler promised but did not?
Yes, to replace what Tyler did not provide.
Okay, thank you. I'm going to hand you what's been previously marked plaintiff's exhibit 16. Can you please describe what that is?
This is an electrical receipt from SNC Electrical Services, and this would be for an electrical box and wiring that Tyler did not provide.
Okay, and what was the total for that?
$3,200.
Okay. And does that fairly and accurately depict the amount that you had to pay yet again for the materials that you did not receive?
Yes, I did pay for these.
Okay, thank you. I'm going to hand you what's been previously marked plaintiff's exhibit 17. Can you please describe what that is?
This is a receipt to repair the driveway that Tyler, when he was delivering partial wood for the barn, he could not back it up the driveway, so he had to scrape the driveway. He tore the driveway up, said he would replace it and fix it after they unloaded it. It's a receipt for $770.06 to replace the gravel and to get equipment to fix it.
So he did not fix the damage?
No, he just dropped off subpar wood.
Okay.
and then left. Said he would come back at a different date.
And does plaintiff's exhibit 17 fairly and accurately depict the amount you paid to replace the damaged drive?
Yes.
Okay. Thank you. Before we move into what you had to do for attorney's fees so far, can you tell me, Mr. Martin, you mentioned that you were doing this as a retirement home.
Correct.
Okay. And can you tell me, as a result of Mr. Miller's actions, have you suffered any hardships in regards to completing the project and having the funds to complete it?
Yes.
Can you describe those for me?
First thing, it's caused marital.
Wait, is this directed toward punitive damages?
This is for the count 3.
For what?
Under the punitive, yes.
Okay, well, you're not entitled to punitive damages or attorney fees in a breach of contract case. So, because there's no written contract which provided for that. So, you know, if you want to put it in the record, you may, but I'm not going to grant it.
And Your Honor, I wasn't going under count 1, I was looking under count 2, the unjust enrichment.
Well, you don't have a claim for unjust enrichment. Unjust enrichment is when a person confers a benefit on someone else that they're aware of and they accept the benefit. That's services or improvements or so forth. You're under a breach of contract case here. And even under unjust enrichment, you're not entitled to punitive damages. You didn't plead a tort that entitles you to plead punitive damages. So, yeah, again, if you want to put it in the record, I'll allow you to do so, but I'm not going to grant it.
Well,
You're not entitled to it under the complaint that you filed. And for default judgment, you have to be entitled to a judgment as a matter of law, even though someone's in default.
And Your Honor, under count 3 of our complaint, the reason why I'm having him go into the struggles that the couple faced is because of the additional costs that they had to undertake in order to complete this project.
Well, again, you've pled an oral contract. Count 3 isn't a claim. It isn't a cause of action, it's a claim. You're alleging that it was willful and intentional. Well, by definition in the law, all breaches of contract are intentional. So you don't get punitive damages. It's not allowed. That's for torts. So again, if you want to put in brief evidence so you preserve your right to take it up on appeal, if you want to do that, that's fine. But I just want to tell you right now that based on your pleading, you're not entitled to punitive damages or attorney fees.
Appreciate it, Your Honor. I would like to just preserve the record. We'll make it very brief.
Okay, go ahead.
Thank you, Your Honor. Briefly, can you describe the costs that you've incurred in order to complete this project, or have you completed it?
No, I have not completed the project. It has caused a lot of heartache. There is no more retirement. I used every bit of my retirement fund.
And what was that retirement fund originally?
Before taxes or after taxes?
Whichever you can recall, please.
It was probably $200,000.
So above and beyond what you've testified here to today, this has been an ongoing issue that you've spent
Yes.
quite a bit of funds to complete this project.
Yes, and every time I talked to Tyler, the material cost was very good, on sale. Amish was going out of business. I've got a deal. I'll store this stuff for you, and I'll bring it when you're ready.
And so plaintiff's exhibits show where you actually had to pay additional costs because you weren't able to receive them at the cost that he initially quoted and promised.
Yes.
Is there anything else that you'd like to let the court know today?
No, Tyler had an excuse every time he was supposed to deliver the material. Every time. And then he wanted to be paid up front to have additional workers come in and put the barn up or do work for him. He wanted the money beforehand. And finally, I quit giving him any more money or writing any more checks to him. And then he just disappeared.
Thank you, Mr. Martin. Your Honor, before resting, I'd just like to make a motion to move in plaintiff's exhibits 1 through 17, I believe.
Yes. All right, those are admitted.
Thank you, Your Honor.
All right.
Can you please step down?
I need to ask him some questions here.
Yes.
I need to look through this first. All right. Mr. Martin, your Exhibit 1 was a proposal for a 32 by 40 subfloor. Is that for a barn or for the house?
That's for the house.
The house, okay. And then exhibit, yeah, I don't have a exhibit sticker on 2, 3, and 4, I think.
Your Honor, that's where we did.
Oh, those are all one, that's right. Okay, I'm sorry. Yeah, I got you. All right, sorry. All right. Page 2, Exhibit 1 was a 36 by 50 pole barn.
Mm-hmm.
And I thought one of your other exhibits you had a cost was for, let's see here, 11 was for a 30 by 48.
The J Brothers.
Yeah, I'm looking for that one here. Let's see. Oh, here it is. 30 by 48 by 12. The 36 by 50 was his quote for the package only. All right. And so this exhibit, plaintiff's exhibit 11, appears to be for the material and labor. It says $10,000 labor, plus a skid loader and fuel. All right. Okay. Now, what materials that were purchased were actually used in your projects? Well, first of all, do you have your pole barn built?
Yes, the pole barn is built.
Okay. And so that was for, and that's the one that was built by J Brothers?
Correct.
And did they use any of the materials from Mr.?
Yes.
Okay. Do you know what materials they were?
They used everything that was there except for
You mentioned
Six.
some of the wood was warped.
yeah, except for 6 posts.
Okay.
There were 6 posts that were not used, that were unable to be used.
Because they were warped
Correct.
from being out in the weather. Okay. Was that from being out in the weather, or were they already warped when they were delivered?
They were warped when they were delivered.
All right. And so, okay. So how many posts were in that that he delivered? Because I see an awful lot of, here I see 14 2x12s, a 6x6, 1 6x6 22 foot, 7 6x6 16 foot. So how many posts were used in this project that were delivered?
I don't know, because the Amish had them already put up by the time I got home from work. And I just know that there were about 6 to 8 posts left that they couldn't use. And the additional screws and metal work that weren't provided.
Well, your exhibit 1, page 2 is a 6x6 post.
6 by 6s. I think that's what they are.
Yeah, well, according to this, there's 7 6x6 by 16 and 1 6x6 by 22. This says there's a package, and then it has on it a 6x6 post, a 2x6 truss, 2 36-inch windows, a 36-inch walk-in door, and 2 12-foot slider doors, white and red metal. So.
Right.
The wood package you say that was delivered, did that include these posts here that he's talking about?
Yes, those,
Okay. But see, what I'm getting at here, in order to make a decision what your damages are, I can grant you judgment for everything that you paid for you didn't get. And then, if you had to pay more for something you were supposed to get than you didn't, then I can grant you judgment for the difference, for the increased cost. But I'm trying to figure out exactly how to match up Exhibit 1-2 and 1 and 11. So I guess what I'm going to do is this. I'll let you, if you, when I'm done, if you want to ask some additional questions, try to clarify that, or I'll give you the chance to file a post-hearing memo to outline that. Because what I'm looking at is, obviously, he's entitled to judgment for, the plaintiffs are both entitled to judgment for what they paid for that they haven't gotten, and any additional cost above that on those items that they didn't get. And that's where I'm struggling a little bit here with the evidence. So, what you have here, because again, I'm having trouble matching up.
If I may, Your Honor.
Go ahead.
Mr. Martin, is there anything on the
Oh,
J
well,
Brothers?
wait a minute. Let me finish and then I'll let you do it. Okay? I have some other questions. All right. What's a mini split?
it's a heating and air conditioning. They're,
Okay. Well, you mentioned also, sometimes you said it mini split, and other times you said HVAC, and I'm not sure, is that the same thing?
it's the same thing. A mini
Okay.
split is a
All right.
style of
All right.
HVAC.
And was the heating, the HVAC system you had, that's for the house,
Correct,
and that's not built yet?
correct.
All right. And you know what the difference is between the Lennox, did you get an estimate for that, for the value of a Lennox compared to whatever it is you've got?
No, I did not.
Okay. Hey, do you know what the brand is that you got?
It was an off-name brand,
Yeah, well.
and I don't know.
Okay. All right, and so I haven't added this up, but all the checks that were presented, is that the total of the 40,000 plus dollars that you indicated you paid?
Tyler? Yes, sir.
Okay. And on the Exhibit 12, that was for the windows, those are all for the house, correct?
Those would be for the house,
All
that,
right.
the replacement, if I had to go get them myself, yes.
And which estimate were those included in?
I think it was just written on one of the checks in a verbal agreement.
Okay, check 9 was for $5,010 for windows. But I don't know how many windows is included in that, but then, so then you got a check, plaintiff's exhibit 12, was for $4,505, that's 15 windows, you said. Yeah, that's the only check I see for windows.
Mm-hmm.
So you wrote him a check for $5,010, but if I'm understanding, plaintiff's 12 was then to get the windows that he was supposed to get on that check. Is that right? That was a low end.
That was the low bid,
All right.
yes.
And then the high end would have been, well, okay, plaintiff's exhibit 14, but that also includes doors.
Yes, that included doors. It didn't include the,
And I don't see any evidence you paid him for any doors.
no, there was no memo for doors, no.
All right.
But he said he had all the windows
Right,
and
but
doors.
you didn't pay him for the doors, so again, what I'm getting at is, you know, for the stuff that you paid more for because he didn't deliver it, or it couldn't be used, obviously I can award damages for that, but for, okay, according to my notes, Exhibit 14 says this estimate is for windows and doors, oh, that's your writing, plus $35.26 for the skylight on the porch. See attached estimate. Do you have any, this does not have any itemization then? I mean, it itemizes what the items are, but no cost that I could see, other than the total.
Other than the total, that's
Okay.
what Lowe's gave me. So,
Okay, so they didn't give you a breakdown on the different units?
no.
Okay, the different amounts, okay. All right.
I think the only breakdown they gave was for the skylights, which was $200.
Well, that's your writing.
Yeah.
I just see a pre-tax total of 32,620.35, and it looks like a whole lot of things in there that go beyond window. I mean, the doors and windows, it
and the
describes
doors.
them, Pella windows and so forth, but I don't, okay. There is one breakdown I see for $2364.89 for Masonite Vista Grand single unit for, I think that's a door.
Yes,
Yeah,
sir.
exterior color peppercorn, interior color peppercorn. And then here is, oh, okay, here's a per unit price of $1994.28 for 5 windows. And that's $9,971.40. Okay.
Correct. And the reason why Tyler's price was so low was he supposedly got a deal on an Amish business going out of sale in Kentucky, and the family just wanted to close it down. So that's why he got such a good deal on windows and doors.
And there's a sliding window for $920. Okay, I do see some breakdowns, all right. So let me go back through here. So page 1 has a door, and that's $2,364.89. So you didn't pay him for any doors, right?
Just verbally. No, I did not pay
No,
him
not what
for
he priced you.
doors,
You didn't pay for any doors, all right.
but a
No.
verbal agreement that he was going to get windows and doors for what I'd already paid him.
Then there's a Pella, 5 Pella windows at $1994.28 for a total of $9,971.40. There is a 7 sliding windows at $928.16 for a total of $6,497.12. This says a double hung 35 and a half, that looks like a window. It says Pella, so I'm assuming it's a window. Yeah, 4 of them, so $967.78. So that'd be a total of $3,871.12. All right. And then page 5 is, all right, so those are the pages. All right, so it looks to me like then page 1's for a door, did not pay him for, according to your count, or according to your memo. And then page 2, 3, and 4 are for 16 windows. You indicated you were supposed to have 15, I believe. Yeah, you said, okay, well, that's, oh, that was in Exhibit 12. Exhibit 12 was 15 windows, and this one was for 16 windows. So what was Mr. Miller's price for? How many windows?
It was for 15.
The same
I
type of
believe
windows?
15.
I mean, the same size windows and so forth, the same quality windows?
Yes.
Again, you
Your
didn't
Honor.
have any specifications in these, you just had this oral agreement.
The oral agreement where he was supposedly in the warehouse looking at the windows and doors.
Yeah. Okay. All right. All right. That's all the questions I have at this point. I still have to review these more closely, but you have any other questions you would like to ask Ms. Wilson?
Just briefly, Your Honor, hopefully to clarify the pole barn. Mr. Martin, can you explain, there were materials that were brought by Mr. Miller
Yes,
for the pole barn.
yes.
Were there any of the materials on plaintiff's exhibit 11 and 15 that are duplicative of the materials that Mr. Miller brought? So in other words, did the J. Brothers quotes include materials you already had?
I do not think so,
Okay, can you
to the
explain-
best of my recollection.
Okay, can you explain that to me a little bit?
J. Brothers told me that the material that they couldn't use, they had to get in addition to what wasn't delivered. So by the time I got there, they had already put it up, and I don't recall what they used, other than I can remember the 6x6 posts were still left there, warped.
In your conversations with J. Brothers, what was your understanding? Were they bringing a whole new packet, regardless of what Mr. Miller brought, or were they just bringing additional items?
They were bringing additional items to make sure the barn could be completed.
And that's your understanding of what occurred to build the pole barn?
Yes.
I have nothing further, Your Honor. Thank you.
All right, you may step down.
Thank you.
Any other witnesses?
No, Your Honor.
All right. Well, I'm going to ask you to submit a memo within 2 weeks to give me some figures on how you feel that the award is granted. I can say this: I'm going to grant judgment for payment. The defendant's order to pay for anything that was paid for that wasn't delivered. Number one. Secondly, for any additional cost for items delivered not used, not usable, and that specifically was opposed. And then third, to the extent that it's in the evidence, any extra cost for materials quoted but not quoted or paid for and not delivered. And so that's what I'd like to see. I know you're claiming $40,000 and or so dollars, a little over $40,000 for what he paid him, but it does appear that some of these items were delivered, so we'll need to know what the difference is between what was paid for and what was delivered. That would be the refund. And then the other components would be for an increased cost for items that were delivered but not usable, and then for materials that were quoted and paid for but not delivered.
Your Honor, if I may.
Go ahead.
Would it be acceptable to this court if, I think especially with the pole barn, if we have an affidavit from J. Brothers explaining the breakdown, would the court leave the record open for that?
Well,
with this
is
memo?
he here?
No,
Okay.
J. Brothers isn't here.
All right. Well, here's the problem, I think. We're not comparing apples to apples. You got apples and oranges, because you have a quote for a 30 by 48 from Martin, and the quote from Mr. Miller is for 36 by 50. Now, when I multiply that out, that's actually, the J. Brothers is actually smaller. So I think Yeah, I mean, I think that's the issue here, so I really am not looking at, and again, the quote for the pole barn package was only for the materials in the package.
Your Honor, that's where Mr. Martin testified, and the additional
Yeah.
3,000 for the labor.
Yeah, okay, I see that, 3,000 extra. Okay, I don't think those bids are ridiculous. Yeah, I've built 2 pole barns myself and I had them built. I've represented a lot of contractors in my day and no homeowners, and I don't think there was ever any doubt or ever any possibility you were ever going to get a barn or any property, because you can't do it for that. He just I agree. You've been had, and I certainly want to try to compensate you for that, but based upon what the evidence, I can only dance you what the evidence supports. So I think I'm okay with that, because that actually, his quote was for a bigger barn than what J Brothers built. So because his would have been 1,800 square foot and 36 by 50, and a 32 by 48 is going to be, I don't know, I can't try and do the math in my head, but it's going to be less than, maybe around 1,600 square foot. So it's smaller. So I'll allow that. Yeah, I'll allow that. But the trick here is going to be to show me what the record shows as the materials, the additional material or the cost. And the labor's immaterial. They quoted a price of $10,000. He said $3,000, but he didn't build it, and you didn't pay him for the labor. Well, maybe you did. I don't see that in the evidence. And if you did, then point that out to me. That would be limited to a difference of $7,000 on that. Yeah. Unless it was paid for, in which case there would be a refund. But again, the refund will be, the judgment for the will be for any money that was paid for which either materials or labor, if it was for labor, was not provided. And then increased costs for what he had to pay. They had to pay for quotes that he didn't do. You would have to pay the difference. So that's where the $7,000 comes from. And then the same with materials. The difference between what they would have paid and what they actually paid. So it won't be for the full amount, but it'll be the difference. That's where I've got to have the breakdowns. So from what I think, he actually paid for $5,010 for windows, so it'll be the difference between that and whatever was actually paid for. So, yeah, if you can file that within, say, 14 days, and then once you get that, I'll take a look at that and grant the judgment and the award of damages.
Your Honor, pursuant to the local rules, would you also prefer to have a drafted entry based on that memo as well?
No, just submit that, because this is a case, whenever I have to issue a decision, I do my own entry.
Sure.
Yeah.
I just wanted to make sure.
Yeah, no
Thank
problem.
you.
Yeah. All right, thanks.
Please rise.
We have two cases here following the same defendant. State of Ohio versus Shana Marie Willie. Case number 24 CR 004 and 24 CR 060. Present for the state's Assistant Prosecuting Attorney King. Present on behalf of the defendant's Attorney Danielle Witt. And are you Shana Marie Willie?
Yes.
All right, the defendant is entered pleas of guilty in case number 24 CR 004 to aggravated possession of methamphetamine, 5th degree felony, and in case number 24 CR 60 to failure to appear, a 4th degree felony. Court ordered a pre-sentence report and have received that, reviewed that. Of each of the attorneys had opportunity to review a summary.
State has your own.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only what contained in the plea agreement, Your Honor.
Swit?
Yes, Your Honor. We also asked the court to follow the joint recommendation. Shana has obviously been struggling with drugs. That's no secret to the court or to anybody in this room. But she is looking forward to going to treatment, and I spoke with her earlier today, and before I was aware that Ms. Sturgill had a bed available for her with a star, she was planning on going to the treatment facility in Adams County.
All right, Ms. Witt, or Ms. Willie, have anything you'd like to say?
No.
Well, you know, you were in court on July the 17th, and I ordered you to report to the probation department to be drug tested. You did not do that. Why?
Because I would have failed.
Well, yeah, we knew that. Yeah. But I think you told me you wouldn't, didn't you? So you knew it would prove you to be a liar, right? Yeah. Then you didn't report back for your interview. You've not been interviewed, have you? You haven't been reporting on pretrial supervision like you're supposed to, have you? And yet you want me to put you on community control or probation, which requires you to go to drug treatment, it requires you to report, and yet you've done none of those things. You've taken no steps to help yourself, have you? I'm asking you a question. Have you done anything to try to help yourself with your problem?
No.
Okay. And yet you want someone to do it for you is what it boils down to. You know, the problem is that if you want help, you have to help yourself. No one can help you become clean. You have to do it. So to say, you know, I want help or I want treatment, well, then show me that you do. And what have you shown me? You've shown me the exact opposite. That you're not willing to even go down to the probation department as ordered by the court. And you already had a failure to appear. And you've done nothing. Now, the only thing I can give you credit for is you showed up here today. And everyone in this room is, other than you and your family that brought you here, are surprised. Because this is the behavior of somebody that's in the wind. But you did come here. So that is to your credit. But, you know, you've done nothing since February when you were, actually you were indicted in January. So you've done nothing to help yourself since January. It was September when you were charged with 23. And I'm looking here in the report, and that's when you were charged with a possession charge. And when you were, after you were charged with that, you were told to report for a substance use assessment at Recovery Council in March, and you didn't do that. Then, as I said, you've really done nothing at all, other than apparently wait for somebody to do it for you. You know, you've done nothing. As according to this, I see nothing to indicate you've ever sought treatment or tried to get treatment. And, you know, probation was trying to help you. The court was giving you a break.
I've never been
You know,
in
what I should
trouble
have done is
before.
just, pardon me?
I've never been in trouble before.
Yeah, I
so-
know. Well, that's not a good thing. That's your fault. Because if you're wanting to straighten your life out, you should be going to treatment. You shouldn't be waiting for the court to tell you you've got to do it. Because I make you get into treatment, that's not going to fix your problem. Your problem is you. And there's only one person in the world that can fix you, and that is you. And you have not shown a willingness to do that. So what it's going to take is something to get your attention. That's what it's going to take. And so what I'm going to do is I'm ordering you, first of all, in case number 24 CR 60, 24 CR 04, you've repeatedly violated the terms of your bond by not reporting, by failing to be assessed as ordered, and then not appearing in court. And then in 060, the same thing. Violated your conditions of bond, didn't report as directed, continued to use drugs and not get treatment, and failed to appear for court. So that offense was committed while you were awaiting release or awaiting sentencing or awaiting trial after being released on bond in 24 CR 004. So what you've done is you've made yourself eligible to go to prison, and I'm going to fulfill that for you, because that appears to be what you need in order for you to be aware that there's responsibility here and that you need to take responsibility for yourself. So on case number 24 CR 060, I'm sentencing you to a term of 17 months, the Ohio Reformatory for Women of Marysville, Ohio. And again, for the reasons I stated, this is not an HB 86 case. And then in case number 24 CR 004, it is not an HB 86 case either, because of the repeated violations of the terms of release. And I'm sentencing you on that case to a term of 8 months at the Ohio Reformatory for Women. But I am going to order that to be served concurrently to that term for a total of 17 months. Do you have the jail time credit there, Ben? Now, upon completion of this term, it is possible that the Adult Parole Authority may choose to put you under what's called post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a parole officer in the term set by the parole authority. And if during that period of time they determine that you failed to comply, then they can return you to prison to make you serve an additional period of up to 9 months for a single violation. But in this case, the maximum is half of your prison term, so that 17 is a prison term, so half that's 8.5 months for multiple violations. However, if you commit a new felony while under post-release control, then in addition, whatever sentence a judge in the new case can impose upon you, that judge is also authorized to sentence you for committing that violation while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. Now, according to the sheriff's records, you were arrested on April the 10th originally and released on the 1st on the new case on the failure to appear, so that's 22 days of credit. And on the original case, you were arrested on February the 2nd and released on February the 5th, so that's 3 days. So that's 25 days of jail time credit. There'll be no fine or driving suspension. You're also ordered to pay the court costs, which judgment granted execution is ordered. If you fail to do that, the court can order you to do community service in this county once you get out of prison, not while you're in prison, and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, what I'm going to tell you is this. I'll consider a motion for judicial release once you've been at the institution for 90 days. Not 90 days of jail, the 22 days of credit, but 90 days from the day that the sheriff gets you to the prison, which will be sometime next week, most likely. And in that consideration, I most likely will, if I grant it, send you to STAR. And I'm doing this because, number one, like I said, I've got to get your attention. You're not paying any attention. And so I'm going to get your attention. Secondly, I want you to understand what's hanging over your head. Because when you do go to STAR, that is a program that's not strictly drug treatment. It is what's called thinking for a change. And that is what you have to do. And you haven't been thinking. You've been addicted and you just are reacting and trying to continue to use drugs, and that's all you're doing. You're not thinking. So hopefully by then you'll be clean and you'll be able to do that. And then once you get through that, then you'll be put into drug treatment, a residential treatment most likely. So that's going to be the help you're going to be offered in terms of, and what I say is this, like I said, we can't help you. You have to help yourself. We can provide you the tools if you want to change, but you have to use them. We can't use them for you. As I said earlier, you know, you need to change, and the only person that can change you is you. Your family can't do it, the judge can't do it, Star can't do it. You have to do it. You have to take advantage of those tools. So after 90 days, I'll consider releasing you to the Star and then to drug treatment. Yeah, but again, if you're not interested in doing that, then you can just do your 17 months. That's up to you. All right. Anything further, counsel?
No, Your Honor.
No, you're-
All right. You're remanded to custody.